Labor markets and antitrust policy, hopefully building on what we heard during the first panel. My name is Derek Moore. I'm an attorney advisor in the Office of Policy Planning, and I will be moderating this very distinguished panel that we have. To my immediate right is Marty Gaynor, who is a professor of economics and public policy at Carnegie Mellon University. To his right, we have Renata Hesse, who is a partner at Sullivan and Cromwell, and both Marty and Renata held senior positions at the FTC and DOJ, respectively, prior in their careers. John Jacobson, to Renata's right, is a partner at Wilson Sonsini in the New York office. To John's right is Eric Posner, who is a law professor at the University of Chicago School of Law and a counsel at Molo Lamkin. And to Eric's right is Evan Starr, who is an assistant professor of management and organization at the Smith School of Business at the University of Maryland. You can read more about each of these panelists in the bio documents that we've passed out. But without further ado, I will pass it on to Marty.
Up there, Derek?
Up to you.
All right, well, I think I'll do that. Well, first, just let me thank Chairman Simons and all of the commissioners for putting on these hearings. I think they're really tremendously beneficial to the agencies, obviously, but to the country as a whole, and it really a credit to both the FTC and the Antitrust Division are taking on a bunch of really tough and challenging issues and hearing from a lot of people with very diverse backgrounds and viewpoints on this. So just a few remarks about labor markets and antitrust policy. And the first panel, by the way, for those who were here, was absolutely excellent. We just had a bunch of top-notch and very, very knowledgeable people discussing these issues. So one thing you heard is there's a lot of concern about wages and wage growth and worker earnings in the U.S., particularly for low-wage workers. And I think one thing that people also gave over well is that the causes for this are not particularly well understood. One possibility that may have something to do, and it might be important, is the possibility of growing monopsony power in our economy. There is some evidence of monopsony power in U.S. labor markets. I think aggregate studies of labor market concentration of wages don't provide much evidence on this one way or another. And I want to be clear about two things there. I think these studies do make an important contribution because they document what's happening with certain measures of concentration and certain measures of wages. As far as telling us exactly what's going on beyond that, as the previous panel made clear, I don't think they're at the point yet where they're telling us what we really want to know, but there still is an important contribution. The second point about this is, as I think Joe Farrell, when he was a BE director in the past, was fond to say, absence of evidence is not evidence of absence. Just because these studies don't necessarily show that there's something going on doesn't mean there's not. And I think actually there is quite a bit of other evidence that leads me to think that there are some non-trivial issues with monopsony power. There's evidence from fast food workers that Dave Card and Alan Kruger did a number of years ago, nurses up to the recent study that was just discussed, teachers, et cetera. Lots of recent evidence of the use of no-poach agreements in some industries, wage fixing, non-competes. In addition, we've heard about declining labor market dynamism and unionization, and while those things are not necessarily declines in competition per se or antitrust, they can magnify anti-competitive effects or have impacts on the workings of these markets in ways that interact with competition. So, as I said, we don't have a lot of evidence at this point, to my mind, on whether monopsony power is growing. And in particular, we don't have evidence on whether monopsony power is an antitrust problem in the aggregate. Even if it's pervasive, we don't know what led to it. And we don't know whether, if firms do possess monopsony power, was it acquired by these firms, say, succeeding in some natural way, which is perfectly legal, or via mergers that harm competition in the labor market or practices that harm competition in that market. The recent evidence from the Ellie Prager and Matt Schmidt study, I think, does point us a bit in that direction, that certain kinds of mergers can harm workers in certain labor markets. And it's important to make clear that antitrust is not the only policy lever to address issues in labor markets. What are things the antitrust agencies, in my opinion, should consider doing? And resource constraints have to be taken into account, but nonetheless, I think there are some things to be thinking about. So one set of things that's within the power of the agency are retrospectives on mergers. How might that provide information? Well, did sell-side concerns address the buy-side as well? To what extent did they not? There were some cases where there have been sell-side concerns, buy-side concerns, but there were not actually sell-side concerns. Are there changes over time? Does labor market monopsony via merger appear to be more of an issue now than it has been in the past? And has antitrust been under-enforced against mergers based on labor market issues? Right now, I would say we actually just don't know about these things. And some efforts to inform ourselves better about this, I think, are sort of resources well used. Another way to do this would be to do things prospectively. As mergers are reviewed, take a set of those mergers and add a labor market analysis to those mergers to try and get answers to these questions going forward. What proportion of these things raise labor market issues? What proportion of these things raise labor market issues that would not have been addressed by product market issues? Labor market studies, I think that rather than trying to do more aggregate level work, I think we did in-depth, careful study at the level of individual markets, analogous to industry studies on the sell side. And there are a whole bunch of issues that can be addressed this way. I'm not going to read everything off the slide. The slides will be posted online at some point. What about enforcement? So here, I think one key thing is that monopsony, by definition, causes harm to competition. And my view is that's the antitrust standard, harm to competition. Scott Hemphill and Nancy Rose and some others have called this a trading partner welfare standard. I think this is one of the many consumer welfare standards going around. There seem to be at least as many consumer welfare standards. I think actually there are more welfare standards than there are antitrust people. But I think this is just very straightforward and common sense. There's harm to competition in this market. It's an antitrust issue. What are some low-hanging fruit or no-brainers? Collusion, wage fixing. So Alan Kruger referred to this Your Therapy source where there was an invitation to collude via text message. This is the modern era. No poaching agreements across firms. Agencies are already taking actions in these areas, but these are certainly areas where if there are violations, they are problematic, they can be pursued. Some things that I think are not as straightforward, but still should be considered, are non-beneficial non-competes. I think there's pretty much agreement that for low-wage workers, non-competes have virtually no efficiency benefits, if any, at all. But of course, in matters like this, one does have to show harm. So thinking about that, with regard to mergers, it might be productive to consider revisiting the horizontal merger guidelines with regard to monopsony power, thinking about analysis of labor market impacts and sort of what that would constitute, considering whether there may be some shortcuts or quicker analyses that would allow one to make conclusions about whether something should go forward, just as there are some on the sell side, and thinking about that. So, and last but not least, considering whether rulemaking authority, which the FTC does have, might be productively applied in this area. So there are a bunch of things to consider, and I think the FTC and the Antitrust Division can't and shouldn't try to do everything, but I think they should be considering what sorts of things they could do that have a high benefit relative to the cost. And I think there's some things in here that would meet that criteria. Let me briefly say that antitrust is part of what I'll call a constellation of policy actors and policies. That makes it sound like everything fits neatly together, which in some sense it doesn't. But the antitrust enforcement agencies play a very important role. Federal agencies play an important role. Various parts of other parts of the federal government, state governments play a very important role. And the key thing here is that communication and coordination are absolutely critical. And this is true for pick any kind of area in the economy. If it's a product side, say transportation, communications, healthcare, there are always other actors that have big impacts on what happens in markets and how well competition functions. And it's important for the agencies to communicate and coordinate with those. And I do want to be clear that the agencies do a lot of that already. But the other thing, again, is there's no one actor here, and one should not be considering actions, policies by one actor in isolation, but be considering how these things fit together. So very briefly, in summary, in my view, there are undoubtedly issues with monopsony in labor markets in our economy. We don't know how extensive these are and whether they've been growing, getting worse. That's really not clear. I think that what we need is more evidence, and I think there are some structured ways that one could pursue that. Some of that can be done by the agencies, whether internally or by commissioning outsiders to do the work. Some of that can get done simply by outsiders, academics, or other kinds of researchers. As far as enforcement, there's some things that are obviously bad, and the agencies can go after that, and they've signaled that they are going to do that. And then I think trying to examine and learn about things where it's not quite so clear is an investment well worth making. And last, I'll just conclude by reiterating that policy towards labor markets more broadly, antitrust is a piece of the puzzle. In the past, it has not been a terribly prominent piece of the puzzle, and it may be that it should assume a larger role, but it should not be considered in isolation. It does need to be considered in concert with everything else that goes on and that everything else that determines competition and the functioning of labor markets. Thank you very much.
Thanks, Marty. John.
And I too want to thank Joe and Bilal and Derek and the rest of the commission for having these sessions. Really informative and important, and thank you for this. So I'm going to start with just sort of the textbook model of monopsony. It requires an upward sloping supply curve. Because only with the upward sloping supply curve will a reduction of output generate lower prices. So the monopsonist looks at its marginal input curve, which the closer it is to a full monopsony will kind of merge with the supply curve, and profits by reducing its purchases to reduce its costs. This is the standard model. In non-labor markets, one of the things we observe is that in markets with significant economies of scale, the supply curve does not necessarily slope upwards. Certainly at the relevant output levels that we're looking at in cases, often you see a flat supply curve. Theoretically, you can see a downward sloping supply curve if scale economies are substantial enough. What that means is that in these markets, traditional textbook monopsony does not work because reducing purchases does not have an effect on price. Now, what's happening in labor? Labor is traditionally considered the textbook example of the upward sloping supply curve. For years, most introductory economics textbooks have taught monopsony by referring to the one company town and other labor market considerations. But the data that we have seen over the last couple of years suggests strongly that wages are down, but the economy is doing well. So looking at it on a total macro basis, wages are down, but total industry output, GNP, if you will, is not down. It's up, and it's been up significantly. So how do we square increased output with reduced wages in a competition context? And I don't have an answer to that because I think it's a difficult problem. There are a number of analyses, and I'm looking at Iona, and hers is probably the most prominent, that associate increased concentration in labor markets with lower wages. I am very skeptical. The data come from a single source, careerbuilders.com, on wages, and I don't know that captures a lot of the superstar wage firms that recruit without using that website. And one of the things that we observe just anecdotally is that the industries that are being attacked as leading the march to increased concentration, these are largely the FANG companies. Those are the companies that pay the highest wages. One of the reasons you saw no poach agreements in high tech is that the wages are in fact so high, not so low. You don't need to have a no poach agreement if wages are low. You tend to be more indifferent unless it's a really unique talent, which actually explains some of the cases that were brought. And so we have Fox is suing Netflix for poaching employees. Amazon increased its minimum wage to $15 an hour. All of this suggests to us that these studies are very preliminary, and it's hard to draw really robust conclusions from any of them. There is just too much that we don't know, and we need to do a lot more study before making significant policy conclusions. Now, where labor monopsony is a problem, it's not clear that the consumer welfare standard is the best way to address it. Consumer welfare, and we're seeing many varieties of it, but it traditionally comes down to lower prices for consumers. Now, if a labor monopsonist reduces output in terms of the purchases of labor, that may in fact reduce output and lead to higher prices at the consumer end. In fact, that's the standard textbook model. But life does not always conform to models, and most firms with significant bargaining power over laborers will tend to reduce the amounts that they pay, or more realistically, not give raises, but not reduce the output that they produce. And that seems consistent with the national trend towards greater output and comparatively lower wages. One of the things that folks have commented on is that labor's share of GNP has declined over years. To me, that is not a particularly important data point, because we are in what the Samuelson economics books that I used as a kid, and many of you used, none of you is as old as me, but many of you studied Samuelson's textbook, and he talked about a post-industrial age where technology was more important to productivity than labor. And we are seeing that. We are in the beginnings of the post-industrial age, and one of the consequences of a post-industrial age is that labor's share of GNP is going to decline. That doesn't necessarily associate it with increased bargaining power for employers or traditional monopsony power. It's just an issue. So getting back to consumer welfare, if in a lot of these cases the result of paying less in terms of wages is going to be to reduce the firm's costs and therefore reduce the prices that it's charged. I'm not saying this is the normal case or even the standard case, but it happens in enough cases that you have to question whether to apply consumer welfare as the appropriate standard. And the standard that I think captures the benefits of the consumer welfare standard without at least that particular potential flaw is an output standard. And let's look, is this practice decreasing market output? Is it neutral? Is it increasing market output? And I think you can apply that to labor markets in the same way that you can apply it to traditional industrial markets. And if we do that, I think we generate better outcomes in a larger percentage of cases than with the low prices for consumers is all that matters standard. So I would urge the Commission to consider output as a, if not a substitute, at least a relevant consideration in terms of determining whether a practice is unlawful or not. Now, what is the consequence of this? What should the Commission do? That's why we're here. I think clearly the no-poach cases are ones that are valid. Other activities involving collusion should also be policed. I also agree that it should have more prominent consideration in merger reviews. I'm not sure I would add a labor specification to the second request. That's going to increase costs. But I think the staff lawyers at the Commission are savvy enough to understand or receive complaints on whether a merger may have a negative effect in a labor market. And when that's the case, that should be pursued. In most cases, and we heard about this from the first panel, taking care of the merger from the sell side is also going to address the labor issues. But that's not always true, and I think that if the staff is simply more sensitive to these issues, that will be a plus. But at the end of the day, labor wages is really not solvable through competition solutions. There need to be additional solutions. Now, one that the FTC could consider, and this would surely be challenged in court, but I believe it would be upheld, is simply a rule banning non-competes or no-poach agreements for low-wage professions. And I think the FTC could do that. There would be terrific pro-competition effects from that. After the 5-year court battle is resolved and the rule is upheld, I think there will be great effects for the economy. The Commission could also consider rules having greater wage transparency, maybe something together with the Labor Department. But at the end of the day, low wages is an important social problem. Whether it's an antitrust problem, there's significant reason for doubt, but there are tools that the FTC has and that other agencies of government have to address the problem. Thanks.
Thank you, John. Eric, you're up.
Thanks very much. Okay, so 6-7 minutes, is that the?
Yes.
So I guess to draw a contrast with the previous speakers, I'm going to urge the FTC not to be cautious, but to recklessly forge ahead to deal with this problem, which I think is much more significant than many people are suggesting. I'm going to make a few arguments, but the theme of my argument is that the contrast between labor markets and product markets. The obvious contrast between the amount of attention that product markets have gotten by the FTC and the DOJ and everybody else, and how little attention labor markets have gotten historically as well as recently. I also want to put aside two red herrings that we've heard. One is that wage suppression or wage stagnation is not simply the result of concentration or other anti-competitive actions. I agree with that, but at least some of it clearly is the result of anti-competitive actions, and that's why the FTC has a role here. The other related point is that antitrust law can't do everything, and I agree with that as well, that a lot of the wage suppression or income stagnation has resulted from other factors, but nonetheless, there's a role for antitrust law to deal with the increment that is attributable to anti-competitive behavior. Now, I don't want to go over the evidence again. That was discussed in the first panel, so I will just put it aside. And I actually want to provide some theoretical considerations and some legal considerations for people to think about. So the first point is simply that firms have just as much incentive to suppress wages as they do to raise prices. It has the same effect. Both actions generate profits. And if they can raise prices through anti-competitive behavior, and they can cut wages through anti-competitive behavior, they're roughly going to be indifferent between doing either one of those. But the fact is that historically there's been much more enforcement on the product market side, as I said earlier. And so any rational profit-maximizing firm is going to look at possible anti-competitive actions on the product market and be a little bit worried that the FTC or private plaintiffs or the DOJ will go after it. On the other hand, if they look at the labor market side and they see ways that they can reduce their labor costs through anti-competitive action, well, until recently, they wouldn't have worried at all about the government getting involved. Same point can be made about mergers, which was discussed earlier. If two firms are merging, they really do have to pay attention to the product market side. They know the Justice Department and the FTC are going to review the merger to see whether it will raise prices for goods. They also know that the Justice Department and the FTC will not review the merger to see if it has any effect on wages, so they don't have to worry about that. And you'd think if they're rational and they want to make money, that that's where they would focus their efforts. There's a somewhat subtler point, which is that for reasons that were discussed in the previous panel, labor markets can be very thin. A big source of labor market monopsony, as I gather labor economists use the term, is the result of search costs and job differentiation. You might think of matching problems as a source of thinness in labor markets as well. And these problems are less significant in product markets. And I would think then that we would be more worried, given a certain HHI for a labor market and a product market, with the labor market, right? So for a given HHI, you might think that the effect on wages will be much more significant than the effect on prices because of these problems that seem to be characteristic of labor markets. Another point to keep in mind is that although I realize the FTC isn't really, a welfare maximizing institution, that it has a narrower mission, it seems very likely that labor market monopsony causes more harm than product market monopoly, because workers tend to be, the workers who may tend to be the victims of monopsonistic conduct will see their wages go down, whereas when prices go up, these are goods that may very well be bought by all kinds of people, wealthy and poor. So I suspect you'll see a greater impact on workers from anti-competitive behavior in the labor market than for consumers generally in terms of welfare. Okay, lastly, I want to talk about some legal considerations which I don't think have been brought up yet and I think are interesting. So we know from people's work, including Evan and Alan, that there's a lot more anti-competitive behavior going on than people believed. The question is, why isn't there more litigation? And if you read the cases, The first thing, you can just type in labor market monopsony or words to that effect in a database of cases, and you'll get a very small number of hits. Whereas if you do searches for any type of product market monopoly case, you get millions. Okay, so why that difference? Why if there is anti-competitive behavior in labor markets and that it's rational for employers to do it, why are there so few cases? Now, of course, one possibility suggested in the previous panel is, well, maybe there isn't that much labor market anti-competitive behavior, so there aren't cases for that reason, and that's possible. But there are barriers, there are legal barriers on the product market side that are not as severe. There are legal barriers on the labor market side that are not as severe as the legal barriers on the product market side. So, for example, labor class actions are a lot harder than consumer class actions. Workers are much more diverse. That means that it's harder to put together a class that reflects a kind of commonality among the victims than in the case of product markets, where the products are often just commodities and the effects on people from a higher price are much easier to calculate. Labor class actions are also more difficult because wage data is more frequently secret, harder to get than in the case of product markets, which is probably why you see less economic research until recently on labor markets that show anti-competitive behavior. Product markets also tend to be national, whereas labor markets are almost always local. Okay, so if you're a plaintiff's lawyer and you need to make enough money to finance the costs and the risks of litigation, it's going to be much more attractive to use a national market than a small regional market. And then the almost final point is that in the product market case, there are often natural corporate plaintiffs, and I believe they're the most frequent types of plaintiffs. So often the victim of a monopolist is another big company that can afford to bring a lawsuit. Consumers might be victims as well, but it's much easier for just a private company to bring a lawsuit. But there are no private companies that are natural victims of labor market monopsony. The victims are just ordinary people who often don't even know that they're victims, who have no idea. And so they're not going to bring a lawsuit. They're not going to consult a lawyer. And then my final point is that because there's so few labor market cases, there's very little demand for experts. And there's very little demand for academic work that looks into them. And there's a circularity here. As a result of that, less information comes out, and people never learn that this problem is as pervasive as it appears to be. By contrast, if you look at what the experts are doing and what most of the economic research is about, it's all on the product market side, and that has this reinforcing quality, which probably accounts for why there's so much more product market litigation than labor market litigation. And with that, I will stop. Thank you.
Thank you, Eric. Renata?
So I thought I'd take us, well, actually, first, thank you. Thanks for having me. Bilal and Chairman Simons and Derek, thanks for organizing us. I thought I'd start first with a little bit of history, and I promise it won't go on too long, which is to say, how did we at DOJ and the FTC come to thinking about these issues and then issuing the guidance that we issued at the end of 2016, which I think has been, picked up by the new administration and at least carried forward in the sense that the Assistant Attorney General at the Antitrust Division has said that he is going to, in fact, investigate and prosecute some of this conduct criminally. So the natural starting point for people in positions of leadership in the antitrust agencies is not one of humility and self-reflection. It tends to be more defensive. And so I confess that when Alan's paper and some other papers came out saying that the antitrust agencies had missed the ball in this area, that the natural reaction internally was to say, well, of course we haven't missed the ball. The next thing was to do a little bit of a step back and be a little bit more humble and do a little bit more self-reflection and ask the question whether there were things that we were in fact missing. We knew that we had brought some cases. We knew that we saw these issues arise in certain highly specialized markets, I would say, nurses, tech markets. But we really didn't know if we had missed a bunch of cases somewhere. So one of the things that we thought we would do was work to create some guidance to put out and just to raise the profile of these issues, because one way that you learn about cases is if you hear from people who have been the subject of anti-competitive conduct, or otherwise they come to you with their cases. And we set up a hotline and all sorts of ways for people to get into contact with us as a way of trying to check to see whether there was a lot that we were missing. I will say that we did see an uptick in behavior that seemed to be translating from more classic civil conduct to things that looked more criminal. So behavior that looked more like wage fixing, for example. And that was a big component in the thinking that we had about saying that we were going to start these investigations going forward criminally rather than civilly, because the conduct appeared to be less rule of reason in nature and more just straight up cartel-like. So where does that take us? So I think the guidance itself is, I think, quite clear, and I think it has been helpful in terms of raising the profile of these issues. I know that in a number of meetings with clients that I've had, these are issues that people are talking about and asking lots of questions. We do a fair amount of counseling around these issues now, whereas I think before they did not get a particularly high profile. But I think there is still a lot of work to be done here. I tend to agree with, I think I'm always feel like I'm charting the middle course in things. I tend to agree with John and Marty that I don't think antitrust, and even Eric said this too, antitrust is not the be-all and end-all in this area. There are a lot of issues that this country faces in terms of income inequality and wage stagnation that should be a very high priority for our legislators and otherwise to try to handle. I think antitrust is one piece of that, but I certainly don't think it's the biggest piece. And I encourage those of you who are making laws and thinking about legislation to really focus on other ways that we could address some of these issues. There's no question that the power of labor vis-a-vis employers has changed in the United States, and I think that's had an impact on wages. The other thing, though, that I think has gotten a little bit lost is that I don't actually think the agencies have ignored this issue. It's just that it's been looked at as a pro in mergers and not as a negative. So one thing that I think as people think about lower wages, fewer jobs, all of these things, that typically that has been characterized as an efficiency. And the agencies have analyzed it as an efficiency, and they've looked at it as a positive that can come from combinations because it reduces the costs that the companies have, and it therefore makes them more efficient and makes lower prices available to consumers. And I think we will need to really rethink how we think about efficiencies if we are going to say that that kind of cost saving is now a harm and not a good. So I will leave it there. We have lots of things to talk about.
Thank you, Renata, and now on to Evan.
All right. Thanks, everyone, for having me. Rather than take kind of a big picture approach in the discussion of labor market competition, I'd rather take you guys on a deep dive into non-compete agreements, which are explicitly prohibit workers from working at competitors. And so this is an emerging area of research, and there's a lot to say, but I want to give you guys kind of the broad overview so you have an understanding of what we're seeing. If you've never had the joy of signing one of these agreements. Let me just read one for you. This is from an Amazon packer in 2015. The contract says, during employment and for 18 months after the separation date, the employee will not engage in or support the development, manufacture, marketing, or sale of any product or service that competes or is intended to compete with any product or service sold, offered, or otherwise provided by Amazon that the employee worked on or supported. Okay, so, I mean, although non-competes have been around since the 1400s, the public interest in them has really only increased after the Jimmy John's case, where minimum wage sandwich makers were prohibited from working within 3 miles of any Jimmy John's establishment, which basically nixed the whole city of Chicago. And after that, policymakers began to question why firms were using these things, how they were being used, and their interest was pretty clear, that firms could use them unscrupulously with low-wage workers even, simply to restrict turnover and reduce wages. And just like firms did in the kind of Silicon Valley no poaching case. But unlike those no poaching agreements, which are per se illegal and invisible to the worker, non-compete agreements are generally not per se illegal because there's a presumption that workers voluntarily agree to them and that there's a clear efficiency motive, which is that firms have an incentive to invest in information and share that information with workers that could make them more productive. If the firm could not use the non-compete, then competitors could hire that worker away and experience the benefits of the information they provided to him. Okay, so because of this efficiency motive, the result is that most states enforce non-competes according to a rule of reason, except for a few states like California and North Dakota and Oklahoma where they're banned. So how should you think about non-competes? Well, I think you should think about them in the same way that you would think about labor market competition. And what I mean is this: consider the following example of a worker who is just accepted a job offer, and he didn't know about any of these non-competes, and he walks into the office on the first day, and the HR guy is running through the paperwork, and they ask him to sign his employment contract. Maybe it's a document that he has to flip through, and maybe it's on a computer screen where he's got to click through and then electronically sign. And he stumbles upon this contract, like the Amazon worker, that says you can't work for 2 years in your chosen industry. And so if you think labor markets are competitive, if you think that the worker can quickly and easily get another job offer, if you think that he can go and credibly threaten to quit and earn the same elsewhere, then the worker's only going to agree to that provision if he's better off, right? If he gets some kind of compensating differential. But if you think that the labor market is not competitive, then the worker might just sign that contract because maybe he doesn't have another offer and he's got to put food on the table tomorrow. Okay, and so the point that I really am trying to crystallize here is that non-competes are a source of monopsony power in that they increase the expected moving costs to competitors, but the price that firms pay for that monopsony power depends upon the competitiveness of the labor market. And in particular, if labor markets are perfectly competitive, workers are going to get that compensating differential where that future monopsony power is transferred back to them. But if the labor market is not perfectly competitive, then firms can retain that monopsony power. Okay, so with this backdrop, I want to summarize some of the research that we're seeing, and I want to emphasize that this research is really still in its infancy, in large part because the use of non-competes is not, the data on use of non-competes is not really available. In 2014, along with J.J. Prescott and Norman Bashara, I wrote and implemented kind of the largest survey of non-competes across the U.S. labor force, and until then, we only really had studies of CEOs and a select few occupations like physicians and engineers. And there's a recent study of hairstylists as well. So here are just a few takeaways from this kind of emerging stream of research. The first one is that non-competes are pretty pervasive. Let me just give you some of the numbers. Recent studies suggest that nearly 1 in every 5 U.S. labor force participants is bound by a non-compete, and that roughly 40% have signed one at some point in their career. Non-competes are more prevalent among high-skilled workers. 80% of CEOs, 46% of physicians, 40% of engineers are bound by them. But they're also found in low-wage jobs, as the recent publicity suggests. 21% of those earning less than the median wage signed one at some point, as Alan and Eric found. And 30% of hairstylists are bound. But non-competes are also found in states that don't even enforce them, like California. 19% of Californians are bound by non-compete agreements, including 62% of CEOs in California. And so sometimes the California model is trumpeted, but we also find that non-competes are being used there as well. And to give you one example, just to show you that I'm not crazy, this is a non-compete from a Silicon Valley-based nonprofit that hires volunteer coaches to take grade school girls on runs after school. And this is the non-compete. It says, as a coach and volunteer for Girls on the Run of Silicon Valley, I may not create or help develop a program that has similar goals and structure to that of Girls on the Run International within a 2-year period of my involvement of Girls on the Run. Okay, so this is a volunteer coach in a nonprofit in Silicon Valley. Okay, so second, when workers are asked to sign one of these provisions, 82% of them indicate that they simply read it and sign it, and some actually admit that they don't even read it. Only 10% of workers attempt to negotiate over these types of provisions when they're asked to sign them, and 1/3 of them actually come after the worker has accepted the job offer already. More importantly, 86% of workers indicate that they weren't promised, or they don't perceive that they were promised anything in exchange for agreeing to these types of provisions. Among the existing studies, 2 of them do find that the use of non-competes is associated with higher wages and longer tenure, so there is some evidence of these compensating differentials. Although one of the studies that I wrote with JJ and Norm suggests that the timing issue is really important, that if you surprise workers with these provisions, then workers don't see any of these benefits. They stay longer in their jobs, about a year longer, and they're less satisfied. Most of this literature doesn't involve data on the actual use of non-competes. Instead, it exploits differences in state policies. And there's significant heterogeneity across the US. And some states, like Florida, non-competes can be enforced even if you're fired from your job. And if you are in California, of course, they wouldn't be enforceable if you got to court. So what this literature generally finds is that the vigorous enforceability of non-competes is associated with slower moving, less dynamic labor markets with reduced wages. And just to cite one study that I co-authored recently, we found that we followed workers for 8 years, and we found that just starting your career in a state with average enforceability, after 8 years, you experienced 5% lower cumulative earnings and you had 8% fewer jobs relative to an equivalent worker in a non-enforcing state. And so, so that's kind of the state of the evidence. There's two more things I want to say, and then we'll move on. So another study that I recently wrote looks at, if you just look at labor markets where the use of non-competes is high and the enforceability is high, what do those labor markets look like? And what we find is that those labor markets are also slower moving, including those not even bound by these kinds of provisions. In fact, there appear to be spillovers that reduce the rate of job offers and the mobility and the wages of those who are not even bound by them, but happen to be in a labor market where they're used prominently and enforced regularly. Okay, and the last thing I want to say is that non-competes chill employee mobility, appear to chill employee mobility even when they're totally unenforceable. In one study, we found that in states where non-competes are not enforceable, 40% of workers who turned down job offers from competitors said their non-compete was a key factor in that choice. And this research, it goes on to say that it's workers' beliefs about whether the firm's going to go after them or whether the firm has reminded them of their obligations that causes them to turn down these job offers, not actual enforceability. And when you ask workers, what do you know about these laws? You may or may not be surprised to know that workers don't know very much. In fact, they even in California, workers don't really know that non-competes are not enforceable. Of course, there could be differences in a few sectors. Okay, so to summarize, even though sometimes the evidence points to compensating wage differentials here, overall, the key theme, in my opinion, is that the use of these provisions and the enforceability of these provisions tends to reduce the dynamism of labor markets and reduce the wages that the workers receive. And I just want to end on 2 notes. First, I'd just like to note that non-competes also belong in a conversation about final product markets, but because they're also constraints to entrepreneurship, and they prevent workers not only from moving to a competitor, but also starting a competitor. And the second is that non-competes are just one constraint within a whole bundle of other provisions, including non-solicitation agreements, non-poaching agreements, arbitration agreements, intellectual property assignment agreements, class action waivers, non-disclosure agreements. And I think what's important to recognize here is that non-competes are very blunt instruments because they literally tell workers, you cannot go work in this industry. And it's possible that that protects legitimate business interest. But once you account for all these other less restrictive provisions, it's unclear what legitimate business interests actually remain. And so it could be that non-competes only serve monopsonistic ends once you account for all those other complementary constraints. And we don't know much about those. So I'll end there.
Thank you, Evan. We are now moving on to the Q&A portion of our panel, and I'd like to remind everybody that staff from the FTC is going up and down the aisles, passing out note cards. If you have a question you'd like to ask, please write it down on a note card, and it will be passed up to me. So the first question I'd like to ask relates to welfare standards. John mentioned that there may be more welfare standards than there are antitrust commentators, which might be true. But I'd like to talk a little bit about some of the problems that John identified with applying the consumer welfare standard to monopsony issues in labor markets. And specifically, I'll point this to Renata and Eric. Do you think that the consumer welfare standard as defined by the courts is flexible enough to address concerns about monopsony power in labor markets, or does there need to be some sort of sea change in how the courts interpret the consumer welfare standard?
All right, I'll start by giving the not surprising response that I actually think the consumer welfare standard is, in fact, flexible enough to address these issues. I mean, I read what John said, and I was not sure why, if you're thinking about any competitive conduct that harms labor or laborers, why you necessarily need to think very much about what the impact of that would be on the end price of the product that the consumer buys. It's not clear to me that you need to go all the way downstream in order to think about where the harm is. This is a debate that has happened many, many times between lawyers and economists, I will say. But it strikes me that the harm is being felt at the employees level, and that the consumer welfare standard is perfectly adept at thinking about that and addressing it.
I agree. I've read as many labor monopsony cases that I can. I didn't find a single one where a court even brought up the consumer welfare standard or thought that it might block an otherwise plausible claim. In the merger context, I mean, if the worker, the relevant issue here will be when you look at a merger, the effects on everybody, consumers and workers. If the workers' welfare goes down as a result of the merger, I think anybody can understand that that's anti-competitive under the Sherman Act, and that's relevant, even though they're called workers rather than consumers. There could be other aspects of the merger that are positive, but as Nancy mentioned in the earlier panel, a merger that has monopsonistic effects will tend to raise prices, not lower prices for consumers. So that's not an issue for the consumer welfare standard.
So can I get 10 seconds of response here? So the problem is the one that you identified earlier, which is that people have been using lower wages and firing people as efficiencies because they argue lower prices to consumers will result. So I do think there's a tension here. Yes, strict textbook monopsony will lower product output and will therefore raise price. But the world is not a perfect monopsony model, and we do see a lot of bargaining contexts where wages are lower or fewer people are hired, and under the traditional consumer welfare standard, that's a plus, not a minus, and that's why I think it's not a perfect standard.
Yeah, I mean, I guess to me, the issue is whether you're thinking about it in isolation or whether you're thinking about it as part of a transaction where somebody's saying, we're going to identify this as an efficiency and we want you, the government, to give us credit for this efficiency and balance it against the harms that may or may not occur on the product market side. I think if you think about these issues in isolation as a monopsonistic conduct that harms labor, then the consumer welfare standard does its job.
Yeah, and I just want to add, I mean, I was surprised when you said that earlier. If it was really the case that the merging parties would say, well, we're going to be able to lower wages, and the government said, well, that's terrific, go ahead. I mean, that's a disaster. All that should be relevant is that they're lowering prices. Now, it may be, there could be reasons why there could be all kinds of reasons why prices could go down that are not objectionable, that are not the result of monopsonistic behavior. But that's what you want to figure out. The mere fact that wages would go down, I don't see how that could be a reason for approving a merger.
Go ahead,
If-
Marty.
If I may, just let me echo that point. So, and this is where this issue comes up, and it's very, very important. It's really critical to distinguish between those two forces. So if a merger enables the parties to do something like invest in technology that leads them, say, using different kinds of labor, and that results in cost savings, then that's fine. That's an efficiency. That's savings. But if the merger enables them to be less competitive in the labor market, and that harm, those wages, that's a harm. You don't get to call that an efficiency. You don't get to count those ill-gotten gains in the plus column.
No, but you do get to count firing employees as an efficiency.
Well, I think, again, it depends on
and
the
that's what I'm
source of
talking
that.
about.
If it not, I would say, if it's true from harm to competition, I would say, no, you don't get to count that.
I understand, but for the last 20 years, the main argument that people have made to bless mergers is how many people are going to be fired. Now, it's not, it's absolutely true, no one's used
It's
lower wages as a
rather troubling,
defense.
I would
It
say.
it is troubling, but it also goes to the heart of the issue that we're talking about here, whether the consumer welfare standard is really the be-all and end-all for this kind of problem. And
But it doesn't help consumers if the firing is the result of increased monopsony, right?
No.
If that's
well,
the
that's
so.
assuming the answer.
So
The
but it
firing
would seem,
blow-
it would seem to me that when the FTC evaluates a merger, it's got to figure out why people are being fired and why wages are going down, right? That has to be part of the analysis.
That I agree.
I agree with that too, but typically the claim is we have tons of duplicative laborers and we're going to lay off half of them because we don't need two headquarters and we don't need two, stores in the same local. That's the kind of firing that we're talking about. And that has typically been considered to be an efficiency, or at least it's been, actually it has been considered and it's been, I think, accepted. I mean, it's not, when the agencies, to Marty's point, I think, when I'm representing a client at the agency, in terms of efficiencies, what you're trying to look for are things like, well, this is going to allow us to build better products, or it's going to allow us to do things faster. There are all sorts of pro-competitive benefits that you can highlight and that you want to highlight. But there's no question that in the synergies column, reducing labor costs is one of them.
But I have to add here, because I didn't know this, I mean, what a striking comment that is, because people in the earlier panel were saying, well, if we ask agencies to look at labor markets, they're not going to have enough resources to challenge as many mergers, and that would be a terrible thing. But it sounds like the agencies are already looking at labor markets and are doing it badly. So they shouldn't, look at labor
I think
markets,
I don't
right?
think that's an
They're
accurate
they're looking,
characterization
they're
at
looking
all.
at the ultimate product
But-
price to the consumer, which is the
Look.
textbook consumer welfare standard, and that's what I'm saying is, works in 98% of the cases, but
Well,
in these
we
labor
don't know
cases,
that.
it really doesn't.
I think there's perhaps a little bit of confusion here. So one, just coming back to this, look, the agency should look critically at efficiencies claims, and everybody knows they do.
Yep.
On this one, perhaps this is an area where a bit more attention is in order. That's not necessarily the same thing as a full-blown monopsony analysis. So I don't think that's what people were talking about on the first panel. And again, I don't think that, in my view, that one has to show that prices get passed all the way through to final consumers, and that's not what happens. Look at the Cisco case, which I worked on when I was at the FTC. Those are intermediate product sellers, right? We didn't look at whether consumers paid more for packets of crackers at the end of the day. The question about there was where the merger of these two huge food suppliers would affect the purchasers, which were retailers, institutions, a whole bunch of things. Pick any healthcare case, almost always involving a hospital named St. Luke's, because St. Luke's apparently is the patron saint of monopolists. And all of those cases have that same characteristic. It is not required by the courts to show that the final consumers, the patients who are getting care, are facing higher prices. So I don't think that's really at issue here.
Although the American Express case makes what you just said a little more complicated.
Well, that would be, and I'm sure
Let's
is
stay
an
away from the
entirely
American
another
Express
panel.
case for this
But
panel.
Supreme Court blew that one big time, in my opinion.
We spent quite a bit of time on Amex yesterday, and we will tomorrow, so I think this is probably not the panel for Amex. I'd like to talk a little bit about non-competes, because we are running out of time. So this is broadly a question about rules versus standards, and in thinking about standards, how we might apply them in the context of litigation. So Evan described how non-compete agreements can be harmful or beneficial depending upon the circumstances. One way to address that would be through a rule or a piece of legislation banning non-compete agreements in totality, like they do in California. Another approach would be similar to what Marty suggested, which would be an FTC rulemaking procedure to ban non-compete agreements for certain classes of workers. Yet another approach, this is what I would call the standard approach, would be to attack non-compete agreements through antitrust litigation. And you might think of non-compete agreement, which is between an employee and employer, is a vertical agreement. And typically vertical agreements are governed by the rule of reason. So in such cases, it's quite difficult to win those cases because you have to prove market-wide harm, and you have to define a relevant market, and you have to show market power. And when we are talking about companies like Jimmy John's, it might be difficult to establish that Jimmy John's has market power in a relevant labor market. So it's a three-part question. Rules versus standards in trying to prevent the bad non-competes while retaining the possibility for good non-competes to occur, and then what sort of things might the FTC think about if we were to pursue the litigation approach. And I'll throw this out to anybody on the panel. Can start with Evan.
I mean, I have a cajillion thoughts on that. So let me just say a few things, I guess. So, in the past few years, in terms of the rules and the role of states and standards, we have seen kind of an unprecedented amount of enforcement actions by state AG's offices, and especially in Illinois and New York. And when you talk to or you listen to those AGs, many of them opened up a hotline. And especially the Illinois AG told me that they got an unprecedented number of calls and hits on that hotline about what's going on, and numerous situations where workers are being threatened with non-competes, but they couldn't make it to court, and they've had a number of high-profile investigations. And so I think that the FTC could do something very similar, where you open up a call line just to learn more information. And I think that's a key here, which is that it's 2014, and we're just discovering how prevalent these things are. And I think that's a tragedy, because workers don't know what they get into, or what they're getting into when they get into a job. And I think that in general, there's a lack of transparency and information about the use of all these sorts of provisions. And so I think a combination of clear policies, whether it's the state or the FTC making the policy, and public information, along with lines where workers can call and report abuses that can then be investigated, is a natural step forward.
Let me add a couple thoughts. I think it might make sense, be sensible, as some states have done, to just flatly ban covenants not to compete for lower income workers. Illinois just did that, for example. What I think is interesting, though, is that the lawyers are accustomed to thinking of covenants not to compete from the common law standpoint, and you alluded to that. I think that Amazon covenant not to compete is certainly would not be enforced in virtually any state. It's absurd, and states tend to be actually pretty strict. You can read a lot of these cases. The judges are pretty tough about forcing the employer to identify the interest and then seeing whether the restrictions are, tailored to that interest. But but common law judges don't look at covenants not to compete from a real antitrust perspective. And as a result, one result, of course, is that there's no real remedy. So a regular worker has very weak incentive to bring a case. The only remedy is that the covenant not to compete is not enforced. You don't get damages or anything like that. And so most workers don't bring these cases in the first place. Only highly paid workers do who have some, new opportunity. The other thing, and Evan alluded to this as well, is I don't think people realize how covenants not to compete may be used on the product market side. And so there are these cases where a business has kind of tied up all the relevant workers, let's say nurses or doctors or technicians of some sort, people who do have skills. And what that means is that when some other firm tries to enter the market, maybe it's an established firm out of state and it wants to come into this market, it can't hire people. And the workers themselves may not even be aware that they're constrained in any serious way. They don't know about the not yet existing competitor who hasn't entered into the market. And so they don't object, they don't demand a compensating differential. I think this is actually quite a serious problem, and more so once we get Evan's data suggesting how that these covenants not to compete are ubiquitous. I suspect a lot of firms have realized that these clauses are a really effective way to extend one's market power in product markets.
Yeah, I'd just like to actually amplify a little bit what Eric said. So we tend to think that for low-wage workers, again, we think little to nothing by way of efficiencies. But for highly skilled people, like, say, doctors, engineers, whatever, we think, well, there may be some real efficiencies. But this is where your point actually comes home. So a hospital acquires a bunch of physician practices, and they make some investments in them. And we say, hey, kind of looks like a non-compete might actually facilitate that. But then those doctors who are key inputs are foreclosed from a potential competitor coming in, and that can harm things substantially in the downstream market. And I think that's something that we do need to be thinking more seriously about.
Yeah, so in terms of whether the FTC should file litigation against non-competes, it's hard to imagine a case broad enough where the impact on a relevant market would be significant so that you would prevail in a Section 1 type case. And the other cases are going to be so narrow that it's not really a huge use of resources. And that's why I suggest a rule. And, rulemaking is always difficult. Here, a line would have to be drawn between the lower wage earners for which there's no efficiency in this or very little, and the CEOs who are inherently in possession of trade secrets that are difficult to protect once the CEO leaves the country, but the company. But I do think hearings and a rule from the FTC, albeit it would be challenged in court, I think it would hold up. And I think it would solve these problems without a lot of lost litigations in the meantime.
So I'd like to move on to talk about mergers again. So an example of a merger that would substantially lessen competition among employers as buyers in labor markets is the merger of the only two hospitals in a particular geographic area. This is an area where the FTC is quite active on the output side. One relevant policy issue for our purposes is how to handle mergers that have labor market effects but do not also have output market effects. So the question is, what do you think is the incidence of such mergers? And do you have any examples of mergers that might present such a narrow labor market question? We spoke a little bit about this in the first panel, but I'm wondering if any of you can think of any questions, and I'll throw that out to the panel.
Yeah, so I think that as I said in my remarks, I don't think we know the extent of those things, and I think that's actually an important thing that the agencies should strongly consider doing, is trying to inform themselves better about how extensive those things are. But so, a classic example of a product market merger that would not create concerns on the sell side, but create concerns on the buy side would say, you have two coal mines, independent coal mines, in a relatively small town in West Virginia, pretty close to where I live, and but coal is sold in a global market. So, so there are no sell-side concerns with that merger, but there very well may be substantial impacts on the labor market. And that is a classic example. There also could be similar kinds of things where there's not a substantial product market overlap on the sell side. Let's say nursing homes or long-term care facilities and hospitals or doctors' offices. If a nursing home merges with a hospital, you'd look at it carefully, but doesn't seem to be terribly likely. You see a lot of overlap on the product market side, and that probably would not likely raise concerns. But there very well may be real impacts on the labor market side.
I can think of a couple real-world examples. One would be there was a wave of mergers involving chicken processing, meat processing companies a number of years ago. These plants are typically in rural areas where the labor markets are thin. Those would be a good example. I mean, it was a while ago. One that was somewhat more recently, because I've been looking for these myself, there were two oil companies that merged. BP was one of them, and then I guess some smaller oil company. And then you might think, this is complicated, but they had operations in the Gulf. Was that a labor market that may have been consolidated as a result of the merger? So those are a couple possible examples.
I'll just say, I mean, I'm confident that you could come up with this, an example of a merger where you have harm in a labor market, but not in a product market. I do think, and I will just reiterate what I said before, that this, if you begin to think about transactions from that perspective, I think people need to step back before they start doing that and really reassess how we are thinking about merger enforcement and what we are thinking about consolidation and how we measure harmful consolidation. Because I think if you're going, in order to find harm in those markets that is actionable, you do have to revisit whether the kind of classic Chicago school way of looking at transactions is the right way to do it. Because I think you're going to find that in many of those situations, what the argument is on the buy side, I guess it is that this is making the company more efficient and, in your coal example, able to compete better in a global coal market. And I'm not taking a position on whether that's a good or a bad thing, but I do think you have to recognize that that will be a change in how people are thinking about transactions, and it will be a step away from the Chicago school.
So we are limited in the amount of time that we have. I'd like to do some rapid-fire policy questions and just run down the line. So the first question, the FTC operates in a world of budget constraints. So let's stipulate that in the near term, those budget constraints are fixed, so we're not getting any more money. And we can also stipulate that the agency currently spends a much higher percentage of its competition-oriented budget on addressing concerns in output markets and not on addressing concerns in labor markets. Given what we've heard this morning and what we've been discussing on this panel, if you were in charge of allocating resources at the FTC, would you divert resources from the output side to the labor side by a little, by a lot, by none at all, and why? So start with Marty.
So I think as I indicated in my remarks, I would find some targeted places to make some investments in generating more knowledge and then proceed from there. So I'd start with a little, but in a very targeted way, and think of these as investments.
So I'll give the classic lawyer answer, which is it depends. And I think part of what it depends on is what else is going on at the agency and where the other resources would be deployed. I certainly think diverting a little bit of resources to these issues and thinking harder about them and trying to understand better how to take enforcement actions if they're warranted is worth it. But I know from my time at the Antitrust Division, there were many, many, many very challenging, very significant output market consolidations going on that required a lot of resources. And there weren't many to spare to look at some of these other issues.
Yeah, so as I said, I would spend the money on rulemaking. I think a retrospective or two focused on labor markets would be good bang for the buck as well.
I would divert substantial resources. As I was arguing earlier, labor market anti-competitive behavior, product market anti-competitive behavior, they're just, substitutes for the firm. And so just think of like the police force trying to catch drunk drivers. If you've got all your resources on Highway 1 and Highway 2 goes the same place, your drivers are just going to take Highway 2. What you have to do is you put some resources in Highway 1, some resources in Highway 2, and I think the same thing has to be done here.
Yeah.
I could convince Congress that the FTC does not need to continually monitor gasoline markets, then I think that would free up some resources that could be better spent in a lot of other ways, this among them.
I definitely think that a moderate amount of resources should be spent on understanding more about labor markets, and in particular, I feel like it would be straightforward to develop some screeners that would indicate at least the use of these non-poaching agreements, non-compete agreements, and understanding what's happening within those firms that are merging. That seems like pretty low cost and easy to do, and
So the second question is going to relax one of the stipulations from the first question. And let's suppose that Congress has appropriated funds to the FTC earmarked specifically for addressing concerns about monopsony power in labor markets. And this is on top of a budget that we already have. So you have a pile of money to spend on addressing labor market issues. How do you spend that pile of money? What Marty mentioned some of this in his opening talk, but what are the first places, or where are the first places that you'll go to address concerns about monopsony in labor markets?
So I'll just reiterate what I said. Go after the stuff that's obviously bad and do it now and don't let it sit. Think about crafting rules on non-competes, as have been discussed, and put some resources into really understanding better what happens on the merger side, where I think that it's potentially highly important and significant, but we also have a pretty big gap in knowledge.
I think I would invest the resources in doing a more broad-scale investigation of the question of whether or not you can correlate growing concentration to wage inequality and wage stagnation. I think if we could actually find studies that people won't always agree on everything, but where there was some sense amongst a core group of smart antitrust economists and lawyers that there was really a correlation between those two things, that would go a long way.
Of course, there was such a correlation with the SCP paradigm back in the 60s, and look where that got us. But I'd spend the same money on retrospectives and rulemaking. Sorry to be simple.
Okay.
I would spend it on merger analysis. And I think the one way to think about this is that there's been an immense amount of consolidation in this country going back decades. With the FTC and the DOJ looking at the product market, I think probably a lot of what was going on is they were saying, well, there's a national market, there's an international market, this is fine, we can let these mergers go through. And all through these mergers, they ignored the labor market effects, which are local and regional and were probable, we don't know, but could very well have been very big. So I think there's a big, chunk of missing social welfare, and the government has to catch up.
I agree with Eric on the merger review, and in particular, I think that resources should be spent on understanding actual concentration for workers, and in particular because labor markets are two-sided markets, and I think that poses some unique matching difficulties, that search costs are really high. And I don't know if we have a good way to generalize that across studies, and I feel like it'd be valuable to put some resources there.
Any last comments in the 35 seconds that we have before lunch?
So I totally agree that I think understanding what happens is important, and I think more research is, I would not spend more time on looking at concentration. For reasons given on the previous panel and actually on other sessions here, I don't think that's a productive activity. I don't think that's going to yield useful research evidence, but I do think that we do need to do more about this, and we think we need to do this in focused studies on specific markets, analogous to the study that was mentioned about the effects of hospital mergers on certain nursing markets. That's where I think the efforts should go.
So please join me in thanking all of the panelists.